Doing what is right may still result in unfairness if it is done in the wrong way. The right thing must be done in the right way. Just ends are not justified through unjust means. The present case is a classic instance of doing a right thing in a wrong way. In their urge to provide a child with due maintenance at the earliest, the courts below have circumvented the due process of law and instead of achieving the desired result, have thrown the parties into a protracted, unnecessary litigation. Under the Islamic law of maintenance of the children, if the father of a child has died or the father, being a poor person, has no financial resources to maintain his child, the obligation to maintain such child passes on to his grandfather provided he is financially in easy circumstances. Thus, the obligation of a grandfather to maintain his grandchild is dependent upon two conditions. The father of the child must be a poor person who has no financial resources to maintain that child, and the grandfather of the child must be a person who is financially in easy circumstances. In case either of these conditions is not fulfilled, the grandfather is not under any obligation to maintain his grandchild. These two conditions are thus also the grounds of defense available to a grandfather against whom his grandchild makes a claim of maintenance. The grandfather must be provided with an opportunity to defend the claim made against him by rebutting the existence of either of these two facts. This is the requirement of the fundamental right guaranteed by Article 10A of the Constitution of Pakistan, which mandates that for the determination of his civil rights and obligations, the matter of providing maintenance to his grandchild is a matter of civil obligation. For its determination, the grandfather must be provided with a fair trial and due process. The Family Courts Act 1964 prescribes a procedure for how the claims of maintenance are to be entertained and decided by the family courts. Therefore, an order for maintenance passed against the father of a child cannot be executed against the grandfather, and the child has to institute a suit for maintenance against his grandfather, in case no property of his father is found for the execution of the order. In the present case, the grandfather was neither a party to the suit instituted by his grandchild against his father, nor was any judgment passed against him. A judgment that was not passed against the grandfather cannot be executed against him. Therefore, always remember to rightly resolve your issues. This case was reported as PLD 2024 Supreme Court 67. Subscribe for rights.